All right, so we're going to do just a synopsis and a summary of transfer, which we're going to talk about specifically title transfer and how title can be transferred. Title can be transferred involuntarily, and there are ways that can happen. And it can be through natural causes, that's wind or water, operation of law, or through court action. I'm just going to give you some simple examples of the three. So, of course, with transfer of natural causes, it can be from erosion, and that's with the action of wind and water, and that can cause property lines to change. And then avulsion, a sudden change in the land mass due to a flood, earthquake, or hurricane. And avulsion does not usually cause a change in the boundary line. Okay, so then we have transfer by operation of law. Title to real estate may be transferred without the owner's consent by operation of statutory law. And some of the examples can be condemnation, and that's when a government agency comes in, such as railroads or utilities. They can take title to real property without the owner's consent by their power of eminent domain. Remember, with eminent domain, the process of eminent domain is called condemnation. Okay? And remember, with condemnation, it requires that it's taken for the public. It's taken from the private owner for a public purpose, and the owner receives just compensation. Okay? And then it can be transferred without the owner's consent through intestate succession. And when a property owner dies without leaving a valid last will and testament, the descendant is said to have died intestate. The estate will then be distributed to heirs according to the laws of descendant and distribution, also called laws of succession. And that's going to take place in the state where the property is located. Okay? And also, a title can be transferred involuntarily through community property. Remember, in community property states, each spouse automatically owns 1/2 of all property that qualifies as community property, even if the title is in severalty, which means the title can be in one spouse's name. In a community property state, the other spouse automatically owns that property. Okay? Also, it can happen through adverse possession. That's each state has a law that provides for an involuntary transfer of title when one person without permission occupies another person's land for the required period of time. Remember, that's squatters. We pretty much call those squatters. And then another way is just forfeiture of title. A fee simple determinable estate is conditioned upon the occurrence or non-occurrence of a certain event. Those are all operations of law. Now we have transfer by court action, and that can be a partition sale. If joint tenants or tenants in common cannot agree on a plan to sever their undivided interests, any one of the owners, with or without the consent of the others, may file a partition suit in court seeking a fair distribution of the property and to dissolve the co-ownership. So it can be done through a partition sale, it can be done through a foreclosure sale, a quiet title action. A quiet title action is if the court determines, as in the case of an adverse possessor suit, that someone else has proven claim to title to the property, the court will order an involuntary transfer to the new owner. And then we have forfeiture of title. And again, that's a fee simple on condition subsequent estate, which is conditioned on the occurrence or non-occurrence of a certain event. And that was the example I gave in earlier chapters, that the Johnson family gave the city of Atlanta land to use as a park. They will own that land with the condition that it is used as a park. If they do not use it as a park, it automatically goes back to the Johnson family or their heirs. So that's forfeiture of title. Those are all involuntary actions on how title can be transferred. Now we have voluntary transfer of title. A transfer of title with the owner's consent is called voluntary alienation. It can be initiated by a government patent or public grant. It can also be initiated by the owners executing a will, making a gift, or selling the property. So transfer by government patent or public grant. A patent is a document used when the government conveys land to a private individual. Then transfer by will. The person who makes a will is called a testator. The document that explains how the testator wants his or her estate disposed of upon death is called a last will and testament. For a will to be valid, it must comply with the laws of the state where the property is located. Again, we're talking about voluntary transfer of title. It can be transferred by gift, and that's a gift deed. Title to real property can be conveyed as a gift during the owner's lifetime unless it is done for the purpose of defrauding creditors. And it can be transferred, title can be transferred by sale. And of course, if someone sells their property, then title is transferred to the new owner's name. So that's pretty much transfer title. In a nutshell, when we're talking about involuntary transfer and voluntary transfer, let's talk about deeds now. A deed is a written instrument when property executed and delivered by the grantor during the grantor's lifetime conveys an interest in the property to the person who accepts it. The person conveying the ownership interest is called the grantor, and the person receiving it is called the grantee. So let's talk about the things required to make a deed. Let's say it this way. Deed requirements for a valid conveyance. So there are certain requirements that has to take place to convey a deed. Must be in writing. The statute of frauds provides that deeds must be in writing to be enforceable in a court of law. There can be no oral conveyances. Also, a deed is not assignable. A new deed must be executed and delivered each time a conveyance is to be made. Another requirement for a valid deed conveyance is that the grantor must be named and must be legally competent. Also, the grantee must be named. A valid deed must identify the grantee in an unmistakable fashion. Legal competence is not required. A deed is valid if delivered to a minor, to an incompetent, or to a grantee using a fictitious name. Yes, there are some, and I gave the example in the class, that sometimes celebrities will use a fictitious name. So, and then there must be consideration. A deed is a contract and should contain a description of the consideration. A phrase such as "for $10 and other valuable consideration" is considered to be acceptable and is frequently used even though it does not describe the actual sales price. Also must have a legal description. It also must have a granting clause, which is words of conveyance. And the words of conveyance are determined by the type of deed and extent of the grantor's obligation to the deed. For instance, the phrases convey and warrant or grant, bargain, and sell are often used in warranty deeds. The phrases remise, release, and quitclaim or convey and quitclaim may be used in quitclaim deeds. We must have the signatures of the grantor or grantors. We don't need the grantee to sign, but we must have the signature of the grantor. We must have delivery and acceptance. Title to real estate is conveyed when a properly executed deed is delivered and accepted by the grantee or the grantee's agent during the grantor's lifetime. This is the grantor's final act, signifying an irrevocable intention that title pass to the grantee. So there are some typical deed provisions. You can have the date. The date on the deed is not essential, but it is customary. You can have a habendum clause, beginning with the words "to have" and "to hold." The habendum clause describes the quantity and duration of the estate being granted. Also, some deed provisions could be reservations and exceptions. And exceptions in a deed excludes from the conveyance some physical portion of the property being granted. For example, Adams conveys 10 acres of land to Bob, accepting there from a strip 15 feet wide along the northerly boundary line. So those are some deed provisions. Covenants of title. A covenant of title is a promise by the grantor that certain conditions of title exist. We can have covenant of season. This is a promise that the grantor does own the property and has the right to convey it. Covenant against encumbrances. This is a promise that there are no encumbrances except those specifically mentioned in the deed. And we have a covenant of quiet enjoyment. This promises that the grantee will not suffer interference from others having a superior claim to the title. Covenant of warranty forever. This obligates the grantor to compensate the grantee for any loss suffered in defending the title against anyone asserting a rightful claim to the property from any time in the past. Covenant of further or future assurances. This obligates the grantor to produce any documents that might be needed to perfect the title. And this may be necessary to execute a correction in a deed if there is an error found. So know the different types of covenants of title. Covenant of season, covenant against encumbrances, covenant of quiet enjoyment, covenant of warranty forever, covenant of further or future assurances. Let's talk about the legal aspects of the deed. We have the seal. The phrase signed, sealed, and delivered relates to a deed, but an actual seal is no longer required in most states. Attestation. That is the act of a person witnessing the grantor's signature and signing the deed as a witness. And also another legal aspect of deeds is the acknowledgement. That's a formal declaration made by the grantor in the presence of an authorized official, usually a notary public, that the deed is being signed voluntarily. Let's go through the types of deeds. We have a warranty deed. A warranty deed guarantees good title to the property. This protection is assured by expressed or implied covenants. And we have a grant deed. This is similar to a special warranty deed and customarily used in some states. The grant deed protects the grantee with only 2 covenants. The grantor promises that he or she owns the property and has a right to convey it. There is also a promise that no encumbrances exist except as noted. The doctrine of after acquired title applies to grant deed. And we have the bargain and sale deed. This deed promises that title to the property is being conveyed, but contains no warranties about the condition of the title, either expressed or implied. Then we have the quitclaim deed. Quitclaim deed. When property executed, this deed conveys any interest in the property that the grantor might have. It does not contain any promises or warrants of titles, and in fact, it does not even promise that the grantor has an interest to convey. And a gift deed, a conveyance for love and affection. A quitclaim deed is often used for this purpose. Then we have title protection. We have constructive notice, and actual notice. Title is the evidence of ownership as shown by the public records. If a title is unsound because of defects which prevent the owner from enjoying full legal rights of ownership, those defects are passed along by the deed to the next person acquiring the property unless the title is cleared prior to the conveyance. Recording a deed gives constructive notice. Actual notice is acquired from what has been heard, seen, read, or observed by making a reasonable and diligent inquiry into all logical sources of information. Recording. All states have recording acts that require each county to maintain an office of public records to serve as a central place for convenient references to recorded documents. The purpose of recording is to give the whole world notice of interest. The document represents and protects existing rights. Methods of title protection. Title reports. Usually an attorney or title company is retained to issue a report on either the complete history of a title or, more often, the title records dating back over a specific number of years. And in Georgia, the title search must encompass a minimum of 50 years. Then we have title insurance. While an attorney or a title company might be liable for personal negligence in searching a title, a buyer has no protection against unrecorded title defects. Unlike other forms of insurance, a title policy protects against what may have happened in the past, not against what may happen after the policy is protected. So usually with a title insurance, you have the lender's policy and the owner's policy. The lender's policy protects the lender against any loss due to a title defect and is valid as long as there is an outstanding balance on the loan. And the owner's policy protects the owner's equity in the property. The protection lasts at a minimum for as long as the owner or the heirs have an interest or any obligation regarding the property. It is not transferable to a new buyer. That's all I'm going to talk about regarding transfer. Just understand some of the things that I covered this evening, and you can go back and listen to it and just kind of understand all the methods and especially when it comes to what's a valid, what constitutes a valid conveyance or different types of deeds. So rewind, and I'll see you in the next chapter. Talk to you later.